last night, Turtleboy did a live interview with one of the jurors who actually sat and deliberated in the Karen Reed case. So it was a very interesting interview. He shared a lot of his thoughts about the evidence and what was actually going on in the jury room. So if you want to see the close to about 3-hour interview, definitely go check out Turtleboy's channel, and he's got the entire interview posted. But what we're going to be doing is we're going to be pulling out some of the clips that I thought were very interesting and worth discussing. And that's what we're going to be doing in today's video. So there's a number of clips I want to get through. So we're going to have to go through this, and hopefully we'll keep this video a lot shorter than 3 hours. So here we go. First, one of the first things that he mentioned was that one of the issues that we kept bringing up on our channel, and that is that how is it possible? A lot of people are talking about this. How is it possible that all those people left 34 Fairview when John O'Keefe's body was allegedly lying in the front lawn, and he's 6'2", over 200 pounds, and none of them saw his body? And he said that actually was a very big problem for them. How is all those people walking out of the house and not seeing that body? So we were not so crazy for thinking that that is something that's very hard to convince a jury of. He also did confirm that the vote was 12-0, that they wanted to acquit Karen Reed on charge 1 and charge 3, which is the saddest part about this, that when you really had an acquittal there, right there on the books, and unfortunately she's going to be facing trial again on charges 1 and charges 3. So he did confirm that it was 12-0 on those charges. But he did also confirm that they were hung on charge number 2. But they all agreed that there was no intent for Karen. Even if Karen Reed did hit him with the car, even the ones that wanted to convict her of that, charge 2, but everybody agreed that there was no intent. So therefore, the evidence of the Aruba incident and those voicemails that she left on John O'Keefe's phone, those did not convince the jurors that there was intent here. Okay, so that's an important part as well. So let's then move on to the clip. And I'm going to play this clip where they're talking about the partial verdicts. And of course, we know that this is the subject of the SJC appeal and their opinion. So let's see what he has to say about this idea of asking for partial verdicts. Okay, let's go.
And you, correct me if I'm wrong, you told me that you and one other juror wanted to ask the judge, Judge Cannoni, whether or not you were allowed to acquit on two of the charges and hang on the third, and that the foreman said, no, we're not going to do that. We have to decide on, it's all or nothing.
So it was not a question of whether we can acquit. It was a question on, can we make decisions on each individual conviction independently of each other
individual charge,
versus,
right,
so that was the question. It wasn't necessarily.
Yes. Right. So acquittal, conviction. Yeah. So but you wanted to ask the judge, are we allowed to come to a decision on 2 of the charges and hang on the third? And the foreman said, that's not going to happen. No.
And it wasn't necessarily just the foreman, but there was a bunch of other opinionated individuals also kind of saying that, no, I think we have to look at it as a whole as opposed to independent. But clearly the person who was in charge at the time was the foreman. So his word or their word was more pronounced.
So there you go. We have something there, which we've spoken about on this channel before. And actually one of my most recent videos, we talked about this, about here you have in the jury room a question of law. And here the question was, are we allowed to come back with partial verdicts? And there was a discussion, and then apparently there was a dispute. Now, this is why it's so important, which I was talking to you about before in one of my last videos, that when you are doing jury selection, one of the most important questions to ask is, when you have a question of law, will you all agree that you're going to ask the judge to determine that the answer to that question? That is so important. And that's where you're empowering the jurors to not just allow the foreman or whoever else was in this jury to tell you what the law is. If you cannot find the answer in the jury instructions, then you got to go write a question and ask the judge. And that is something that I always stress to the jurors. And now, definitely Karen Reed's defense team in jury selection. And he actually gets into a little bit of the questions during jury selection. I would have liked to ask him a lot more questions about the jury selection. We'll get to that soon. But this is why if you're on the Karen Reed defense team, you got to make sure during the jury selection that you tell the jurors if there's any sort of question of law that you have in the jury room, don't decide amongst yourselves. Don't let the strongest voice decide. Will everybody agree with me that if you have any sort of question about the law, you are going to ask the judge? And if you get all the jurors to agree with you, then that's it. Then anytime that this situation should arise, it would arise in jury deliberations, they'll say, well, we already told the lawyer that we're going to ask the question to the judge, so let's just ask the question. There's nothing wrong with asking that question to the judge. And if the foreman says you can't ask that question to the judge, you say, well, then we'll ask if we're allowed to ask that question to the judge. So that's in terms of that. Now, they talked about also a little bit, I'll just remove it for a minute because we're going to go back to it in a minute, but they also asked a question about the reference to the Asian house. So this is one of the questions that was asked of one of the witnesses. I forgot who it was right now, but they said about, the Asian house. Now this Ronnie is Asian, and he asked him, Turtleboy asked him, he says, did you feel that that was offensive? The way that they refer to that house is the Asian house. Like those are the Asian neighbors. Were you offended by that? So he said personally, it didn't offend him that much. It didn't bother him that much. He was born and raised in America, so he didn't really feel like it was too offensive. But he definitely did see how people could be offended by that line. So again, it's definitely worthwhile if you're on the Karen Reed side to bring that point out in cross-examination. And maybe if you have another person on the jury, and even if you're not from Asian descent, but it still can be a sensitive point to you that why they're referring to this that way. So he said personally it didn't bother him, but it could be other people on the jury did. So definitely something worthwhile bringing out again on if you're Karen Reed defense team. Now, they also spoke about the closing arguments. And remember that Brian Albert and Colin Albert and Jennifer McCabe all came and sat for the closing arguments and were staring directly at the jury. And there's a lot of discussion about that. Do you think that that was appropriate? Do you think that they were trying to intimidate the jury? And this juror actually said that it was intimidating for him. It actually was intimidating. They wanted to put some end to this case, wanted to put some closure. And, they got those people coming in and looking at him. Now, they're allowed to be there and they're allowed to look at them. They're allowed to do that. But he just said that he did feel some sort of intimidation. So if that was their point, I guess that they succeeded. Okay. Now, we all know that one of the big issues of this case was the fact that when Karen Reed was allegedly saying, I hit him, and she wasn't even asking as a question. She was actually saying it as a statement. And we've discussed this issue a lot of times. But one of the questions was the failure to document anywhere that she actually said that. Definitely in the initial reporting on this case, there was not documented anywhere where she said, I hit him. Now, this person, Ronnie himself, is an EMT. He is an EMT. So Turtleboy asked him about this specific case right here about documenting this type of information when you are treating a victim. So let's go to that point. You have to just get ahead to it. It is right around here. All right.
There's nothing there.
So you are an EMT, which is such a unique job, it's particularly for this case. And at the scene, the EMTs were the kind of the first people to testify. And I think they interviewed like 8 or 9 of them. And 2 of them, I apologize. 3 of them testified that they heard Karen Reed say, I did it. If you came across a car accident or something like that with a dead body on the road and there was a woman screaming, I did it, would you tell the police what she said like then and there, and this woman's confessing to a crime?
I honestly would focus on taking care of the patient and not necessarily focusing on that individual. That being said, if that individual was my patient, then obviously I would need to disclose that information to law enforcement. But at that time, if my patient was Mr. O'Keefe, then I would focus on Mr. O'Keefe and his resuscitation first and foremost.
To be focused.
So that is, which is a pretty understood type of answer, right? I mean, like if you're the EMT and you've got someone who's dying, then you're not going to be concentrating, hey, you know what he just said to me? Of course, you're going to be trying to resuscitate your patient. The question is, what about after? After, and then he said, yeah, well, obviously I would have to report that to the police that he did say that. But there was no follow-up here about whether after you're done trying to resuscitate your patient, would you then document in your end of shift report that that this person said, she said, I hit him, I hit him, I hit him. Is that something that would be normal in your line of work to make sure to document that in your end of shift report? And, because there's no records of that. So that would have been a nice follow-up to that question, but he didn't really go there. Now, here's what gets to I think the most very important part of this interview. And he talks about the ARCA experts. And as you know from my channel, the ARCA experts to me is what sealed the deal in this case. That is exactly what showed that there's reasonable doubt. And really, that's any time that I'm having a discussion with someone on the other side who believes that she should have been found guilty, they usually don't have a good answer to that. They try to say that they didn't have all the information and things like that. But that we've gone through all those arguments and why they don't fly at all. But let's see what this juror has to say about the ARCA experts. So let's just get it ahead to that point. And here we go.
Okay.
Well, luckily, there were 2 experts provided by the federal government from a company called ARCA that testified, 2 doctors, and they were the last 2 witnesses to go. And they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find Karen Read guilty of manslaughter, you have to listen to the ARCA experts and say, I don't believe them. So how did 8 jurors reach the conclusion that those guys didn't know what they were talking about?
It was as a direct result of Karen was there at that time, and John was there at the time, and it was believed that John died there, therefore, right, at that location, and therefore it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house, and as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle, and with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow, some sort of involvement by Miss Read. So that was how they all arrived at.
But how did they reconcile? Was the ARCA testimony brought up by the people that thought that she was not guilty? But I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on why these individuals were testifying. And so there was a question in the group on their essential integrity, in terms of, were they there as a direct result of somebody else trying to steer us in a different direction and confuse the jury. So it wasn't sure if it was insurance. It wasn't sure if it was, whether the Reads were doing it, somebody else was doing it, or yourself was doing it to bring this group to try to testify so that it would sway the jury in one direction or the other. And I think that was one of the things that was, again, unfortunate, because I guess it cannot be said, or didn't want to be revealed to us on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
You see something that we did not hear, something that I've been hearing every time I talk about this, that it must be that the reason why we couldn't believe the ARCA experts, it must be that this is what the jurors were thinking about, is that because the ARCA experts were just lacking enough evidence. They didn't get the full picture. They didn't see the actual Lexus, and they didn't have the text stream data, and they didn't have this data, and they have that data, and they didn't have enough information to come to their conclusion. That must have been the reason why they've found that some of the jurors felt that she was guilty. We didn't hear that. We didn't hear about that they didn't know about the DNA on the John O'Keefe's DNA on the his piece of hair or whatever on the tail light. That wasn't the reason that he gave. So I mean, it was creative by by the people that want to convict her. But it's what his reason was, is that they seem to just didn't want to believe them. They just didn't want to believe them because who knows why they're here and who hired them. Was it an insurance company? Was it, was it Turtleboy? Who hired these people? And that's even a worse reason. I mean, like the other reason, okay, at least we can debate it. Like this reason is, well, we don't know what brought them here. Okay, that's, we don't know who brought them. Okay, so does that mean they're lying? Does that mean that they're not believable at all? Does that mean that they're not credible? Does that mean that they're not real doctors? So do they fabricate everything? Are they making up this stuff? They're perjuring themselves on the stand? They're saying that it doesn't fit with science, but really it does fit with science, and they're just being hired to say that? But that is apparently what a lot of these jurors felt, which is very, very puzzling. Very puzzling how, I understand if you don't know where they came from. Okay, so that's a question. Where did they come from? Who hired them? But we know very clearly the defense did not hire them. That was clear. You can't say that the defense hired them. So we don't know how they got involved in the case. Okay, fine. So we don't know how they got involved. So if you don't know how they got involved, that means that there's reason to doubt that they're actually saying the truth, that they're actually real doctors and real experts. Just completely discredit everything that they say. It doesn't even create reasonable doubt in your mind. That's all they have to create is reasonable doubt, because you don't know who hired them, and there's nobody contradicting them. By the way, there's no one contradicting them. And he's going to say soon that Trooper Paul, they all agreed was a joke. So they didn't give any credibility to Trooper Paul. So who's contradicting these ARCA experts that, well, we don't know who hired them, so therefore they just completely lose all credibility and we have to convict her? And it does not exactly sound extremely well thought out. But that was apparently what some of the reasons were. You can't argue with them that, jurors at the end of the day, like we always talk about, jurors can do whatever they want. And that's part of the risk of going to trial, is that jurors can make these jumps and conclusions, even though they are not grounded in facts or evidence or science. So that's just one of the risks that you always have when you go to trial. He also talked about the dog bite expert, Dr. Marie Russell, I think that's who he's referring to, that they weren't sure why she was brought in talking about the dog bites and, how they thought that was to confuse them. And I mean, again, I don't understand that so well, because obviously we're trying to explain what these injuries are from. So the whole case is that this is not from a car accident. So it's from it could be from a dog. It's a reasonable conclusion. And now we have an expert saying that it's consistent with being from a dog. So I don't know why they were so confused by a dog expert, and they thought that she was just being brought in to confuse everybody. I mean, she was brought in to say what those injuries are from. I mean, it's pretty clear. That's one of the most essential parts of this case, right? Okay. Now, something else that he testified to was that, not testified to. One of the things that he said was that all the jurors there felt that the McCabe's and the Alberts were being truthful. Okay, so they didn't completely discredit the McCabe's and the Alberts. Like a lot of the people feel that it was very clear that they're being untruthful and they were just tripping over themselves right and left. And, but he said that by and large, the jury believed the McCabe's and the Alberts, which is why you'd have to believe them to say that he didn't come in the house. That's what you have to believe. So he said that they did believe them, essentially. Now, let's get into when he's talking about the actual theory of the case, the Commonwealth theory of the case, and what he felt about that, or what the jury felt about that. Let's just move ahead. This is at 39. 7. Just give me a second, and here we are.
That John, that his arm, I still can't believe they said this theory, that the arm was out, and that the arm is what caused the taillight basically acted as a knife and just sliced his arm up, and then caused him to spin and then land 30 feet on the grass. And the gash in the back of the head came from hitting the grass, which they said was so hard that it somehow caused a gash in the back of his head. People really believe that?
Yeah, I mean, I don't think a lot of people in the room, some people who were experts in science, right, and physics, or have some knowledge of physics, necessarily believe that as the case, given the circumstances, that it was not very clear.
Mhm.
But again, some individuals just believed at just the circumstance that Karen and John were there at the same time, and John ultimately was killed.
So what he just explained, which is like so incredible, is that the jury didn't even buy the Commonwealth's theory on this case. They didn't buy it, really. What they hung their hat on is that the jurors that wanted to convict Karen Reed is that it's circumstantial. I mean, look, the last two people together were Karen Reed and John O'Keefe, and they were both drinking, and John ends up dead. So the most reasonable conclusion is that she had something to do with it, even if it doesn't fit within the evidence, even if it's against the science and the physics. But the circumstances, but he kept saying circumstances. He said circumstances a lot of times in this, which seems to be there's a lot of circumstantial evidence that Karen was there at some point. Her car was there at some point. They believe the McCabe's and the Alberts that he didn't come into the house. And therefore, the only rational conclusion is that she hit him. Now, even though, and this is how he explained why, they were okay ignoring the ARCA experts, even though that was, their reason wasn't the greatest. But, I mean, what other explanation is there? Whether if we believe the McCabe's and the Alberts, and we don't have any other explanation how this happened, well, then it has to be that she did it. And this also comes back to one of the points that I talk about in my videos about what your job as a defense attorney is. One of your jobs is to tell the jury, you're not here to solve this mystery. You're not here to say, well, we have three options and you got to pick one. What your job is to test the theory of the Commonwealth. And if that doesn't equal, if they can't prove it to beyond reasonable doubt, then the case is over. You don't have to solve this. You don't have to put the pieces together. There can be a lot of information that you don't know, and you'll never know. But that's not your job. Your job is simply to test the Commonwealth's theory. And if the Commonwealth's theory does not fit within the evidence and the facts and the science of this case, then you have to acquit my client. No one's asking you to figure out how this happened. You're not investigators. You're not detectives. You're here to test the Commonwealth's case. And if they can't prove their case beyond a reasonable doubt, then it doesn't matter how this accident happened. It doesn't matter how this death happened, how this murder happened. Could have happened in a million different ways. That's not your job. That's why it's so important. As we see, they felt that they had to solve this case. And because there's no other reasonable explanation, they said it must be that. I mean, again, in their minds, and they didn't want to buy the conspiracy because they believe that the McCabe's and Alberts are being truthful. Well, then that only leaves one other option. So that's why it has to be very clear. If you're the defense, during jury selection, you got to hammer this home, probably during opening statement and during closing arguments also. That's not their job. Their job is simply to weigh and examine the Commonwealth's theory. And if the Commonwealth's theory does not fit within the evidence of this case, then the case is over. Your job is complete. That's it. You're here to judge the Commonwealth's theory. That's it. So that's what we saw as well. Now, he also asked them a question about, did they understand reasonable doubt? Did he think that the jurors really understood reasonable doubt? And he first said that he thinks that they did. And then he kind of walked it back a little bit, because he was saying how, it would have been very helpful to have a lawyer there in the jury deliberations. And there was someone, I think it was an alternate, who was not allowed to, he was chosen not to deliberate, or she, I'm not sure who it was, but there was a lawyer, and that lawyer was not chosen to be part of the deliberating juries. And he said it would have been helpful to have a lawyer in the room. Now, if you understood reasonable doubt, why is it helpful to have a lawyer in the room? So it must be, I think, reasonable inference is that they maybe did not understand reasonable doubt. And definitely within the definition that the Massachusetts gave, that it has to be a moral certainty. And it has to be the highest degree of certainty possible in matters relating to human affairs. And that can be explained. Okay, so again, one of the jobs, and I know it's hard, and I know it's, looking at the case from 30,000 feet, it's easy to pass judgment. But this is also why, closing arguments, if it's limited to an hour, it's hard to get through all this stuff. But one of the things that you got to do is explain reasonable doubt. Maybe in opening statements, maybe in jury selection, usually in jury selection. I like to explain these things a number of times. But to try to explain reasonable doubt very, very well so that everybody understands how high the burden is and how much the Commonwealth has to prove their case by with a moral certainty. So I think that according to his answer, it could be they were a little bit confused about the actual burden on the Commonwealth. But you got to really read between some of the lines, some of the answers that he's giving there. And there's a few different areas in the interview when he's talking about it. So that's just something. But now he also asked, would it made a difference to you if you would have known that the FBI hired the ARCA experts? And obviously the answer to this is yes, of course. If they knew that the FBI hired these ARCA experts to look into the investigation of the police, then they would have given it a lot more credibility. You think that maybe would have completely tipped the scales in Karen Read's favor. And this is also part of the reason that you can argue from the Commonwealth that that's why it's not fair for it to be admissible, because it's unduly prejudicial. It's too prejudicial against the Commonwealth to allow them to know, allow the jury to know the FBI is investigating them. They would just automatically assume, okay, then this investigation must be garbage. And it may be, but if you're trying the case, then you don't want the jury to know that, and that can really sway the jury instead of them basing it their verdict on the evidence. Now, he spoke about jury selection a little bit, and I really, really would have loved him to get more into the jury selection process, because I keep telling all of you that it's not something that we get to see on the outside. I'd love to see the jury selection, and I'd love to see the questions, because it's such an opportunity. I know you've heard it from me a million times, but it's such an opportunity. You don't just talk about bias. Of course, you do that too. You talk about bias. You talk about, are you going to be able to be fair and base your verdict just on the evidence alone, and nothing else is going to sway you, etc. But you also have to do so much more during jury selection. It's really a time to start planting seeds about the arguments that you're going to be making in your case. Really, you should spend a lot of time on jury selection. So he said that one of the questions that they asked him, and this is from the defense, was since he was an EMT, he said, would you be biased because of the medical training that you've had, and you won't rely on the evidence in this case? And number two is that, are you going to be biased against and for law enforcement? Because you may be working with law enforcement a lot as an EMT. So do you like law enforcement a lot, or are you against law enforcement? They want to make sure that you're not just going to automatically side with law enforcement because you're an EMT. So that was one of the questions that they asked, which is a good question. Of course, you have to ask that question. But I would have loved to hear much more about the jury selection. So if we're going to do another interview, please, all the people out there that are going to be able to interview jurors, and if any juror wants to come at my show, please let me know. Love to interview you. I'd really like to know about the jury selection process and what type of questions were asked by both the Commonwealth and the defense. That would be really an interesting piece of information I think everybody wants to know, because it's something that we're all blind on right now. Okay, then he spoke about Trooper Paul. Okay, Trooper Paul, he said, quite frankly, he said, he doesn't know if the cameras picked this up, but a lot of the jurors were laughing at Trooper Paul because he didn't know the basics of physics, and he's supposed to be this expert in reconstructing this accident. And he said nobody actually really gave any sort of credibility to Trooper Paul's testimony. So no one was really hanging their hat on Trooper Paul's reconstruction, explaining how all this happened. Again, it really all came down to the circumstances in this case. It's just they were there together. They were drinking together. They were out together. And now there's only two people there. He didn't go in the house, according to all these people, which they believe. So then what's the most reasonable explanation? And that's not what you want the jurors to do. But that's what the jurors did in this case, at least the ones that wanted to convict. They said it's a reasonable explanation. So even though you have ARCA experts against you and you don't even believe Trooper Paul's reconstruction, you're still going to say, okay, well, that's the most reasonable explanation. And that's not your job as a juror. It's really, really not your job. Your job is to determine how good the Commonwealth is putting on their case. And that's it. You're not there to solve the puzzle. All right. Well, I think I've said that enough. He talked about the Google search. And what he said about the Google search is something very similar to what I've been saying this entire time. And that is that he felt that the Commonwealth experts, Jessica Hyde and Ian Whiffen, definitely created a doubt about whether Jennifer McCabe did that search at 2:00 in the morning. So that's really what I've been saying, is that they were credible enough to say that we're not 100% sure when Jennifer McCabe did that search. So if you have all the other, if they would have all the other evidence pointing in Karen Reed's guilt, and that's the only piece of evidence that would suggest a conspiracy, then they would be able to find that Karen Reed, hit them, and she didn't. And Jennifer McCabe actually did not do that search at 2:27 in the morning. So that's basically what he said. Basically, what I've been saying to all of you is that those experts definitely was a battle of the experts. When it's a battle of experts, the jury doesn't really know what to do. And if therefore they have other evidence that's pointing one direction, they may just say, okay, well, this is we have experts on our side to finish this puzzle, and therefore that's how we're going to find. So he didn't say he's convinced that she did do it. She didn't say that he's convinced that she did not do it. But he just has enough doubt he doesn't know when she did it. And therefore you look to the other evidence to answer all your questions. Okay, then he spoke about Michael Proctor, and he said that those text messages alone from all the jurors, Proctor lost all of his credibility. Now you can imagine those are just the text, those are text messages that we heard from the last trial. This next trial, we're going to be hearing about his suspension because of those text messages also. So we're going to be hearing about administrative action that was taken against him to suspend him without pay because of his actions that he took in this investigation. So it's not just limited anymore to the text messages. We're most likely going to be hearing about this, and maybe Hank Brennan's going to try to file a motion to keep this out. But to me, in my mind, it should be admissible. And we'll see if he actually gets permanently terminated. We'll see if that happens before the trial. So if he lost all his credibility in the last trial, then definitely this next trial is going to lose all credibility. And that's why I keep saying that if the Commonwealth does not call him for whatever reason, if you're the defense, you call him. You call Michael Proctor if you're the defense. And you show exactly what he's been saying in his text messages. And you talk about the suspension. All right. He also spoke about Brian Higgins destroying his phone as very suspicious. He said they all agreed with that also. It was very suspicious. And then he spoke about the 3 flight of stairs. What about John O'Keefe's phone registering 3 flight of stairs? And he said the following. He said, well, if there would have been an Apple expert, that would have been very helpful to the jury. If the jury would have had some sort of expert explain when your phone could register steps, when they can't register steps, and whether you can manipulate that and pretend that you're doing it and get some sort of Apple expert, that would have helped a lot. Now, the truth is that Rich Green did testify that he tried to manipulate it and tried to trick it into registering a step when he didn't really take the actual step. And he said he couldn't do it. He couldn't figure out a way to do that. And, maybe he's not an Apple expert, but he tests phones all the time. It's part of what he's doing, right? Celebrate extractions, and he tests phones and he looks into phones. This is part of what his expertise is. He's maybe not from Apple, but he did testify to that. So I don't know why they need something more. I mean, okay, if you have something more from Apple, okay, that would be the best. But he definitely had some testimony there that you cannot manipulate these phones. And that's also that fits a lot with common sense. Fits a lot with common sense. They're spending all these, who knows how many millions and millions of dollars on this technology. You would assume that you can't trick it. So, and then he spoke about, well, what about if Karen Reed's phone did not register the steps and did not register the flights upstairs, and John O'Keefe's phone did? What would your takeaway from that be? And he said, well, that would be that would definitely be very, very interesting, and definitely may sway some of the jurors. So that's it about that. Okay, now let's talk. Well, I'm going to play some more clips for you, and these have to do. First clip we'll play here is about the butt dial. Remember, this is one of the issues that we always talk about as well. What about that butt dial? What did the jury think about that? It doesn't make so much sense that there was a butt dial that Brian Higgins and Brian Albert made to each other, right? So let's see what he has to say about that. This is 113. Okay, let's start here.
To what was being said or what was going on in the courtroom.
Okay. Do you believe that Brian Albert butt answered his phone while having sex with his wife at 2:22 in the morning?
I find that very hard to believe, but anything's possible.
Yes.
So again, one of those coincidences that we've spoken about on our channel, that's hard to believe. All these things are just really hard to believe. The butt dials, nobody saw him coming out of his house, destroying your phones. These things are hard to believe. That's what I've been telling you. And apparently the jury agrees with me. So let's go.
This is from Denise Tuttle for $10.
This is about, do you think that Karen Reed was framed? Basically, do you believe in the conspiracy? So listen to his answer here, because I think it's very interesting.
Says, does this juror think she was framed? And has anything he's learned since the trial changed his mind?
So I think there's a lot of bias in the investigation, and therefore it's hard to go in that direction of, I think it created enough reasonable doubt in my mind that she was not guilty. Whether she was framed, that's a different scenario. But again, a jury would look at it and say that she's not guilty based on reasonable doubt. So,
well, if Karen,
so there you go. I mean, this is what I've been saying for a long time. Also, is that it's much easier for the jurors to swallow the fact that there's reasonable doubt than to assume that there's a conspiracy, to assume that she's framed, to be able to swallow that and say, look, if these are the two choices that you're giving me, she's either framed or she's guilty, it's going to be hard for the jury to say that she's framed. It's just a harder leap. So therefore, you're making your job a lot harder if you're the defense by hanging your head on the conspiracy. And he's going to talk a lot bit more about this a little bit later on. So I'm going to let him tell you a little bit more about this. But this is what he was saying. He was saying, yeah, I had reasonable doubt. I mean, this investigation that was not done properly. Definitely created reasonable doubt. But I'm not ready yet to say that she was framed yet. But there's a lot of problems here. Okay, so now let's go into a little bit further, which again brings out another point that I was talking about to you guys. And I'm not just doing this to show you that I'm right. How petty would I be just to show you guys that I'm, you should listen to me. But let's just see what he has to say about defense attorneys trying to explain jury instructions or any sort of explanation to jury instructions, especially when they're confusing.
This is from Not Man Shannon for $10 and says, if the defense took the time in closing to go over the jury instruction and relate each piece of evidence that establishes reasonable doubt to each jury charge, does Ronnie believe this would have helped the jury vote not guilty? I think we've kind of asked this already.
I believe that it would have probably been helpful to be able to have more of the data and clear instruction.
So that's what everyone keeps talking about in this case. And I've talked about this a lot as well. To explain the jury instructions to the jury. That is your job as an attorney. If you want to win your case, and again, I know closing arguments are only an hour long. For a long trial, it's a limited amount of time. To explain some very important jury instructions to the jury during that time is so incredibly important that can literally win your case. So that is something that he's saying would have been helpful. I think everybody understands it in this case. It just brings out my point a little bit better, but I've been doing this for a while. This is what I do. You got to explain the jury instructions if you can. So try to incorporate that into your closing argument, and it would have gone a long way. Okay, now talks about searching 34 Fairview. We've spoken about this, and I've spoken about this with other attorneys. I mean, every time I speak about this, it's clear to me that if you invite someone over to your house, and then that person ends up dead on your front lawn, that house is going to be searched. There's absolutely probable cause. So I've spoken about this a few times, and now let's see what the juror has to say about it.
That's the mystery, right?
If you invited
but
someone,
it doesn't seem consistent.
If you invited someone over your house after the bar, and then they ended up dead on your lawn 6 hours later, would you expect the police to search your house?
Well, unfortunately, if that were the circumstance, regardless of who it was, I would believe that law enforcement would comb my house and potentially go to each neighbor and interview each neighbor, and more testimony from neighbors and other individuals would have been presented. I don't know if that was just dismissed because they didn't think it was relevant testimony by the defense nor the prosecution, but I think it would have been important to have interviews of the neighborhood or individuals, including a search of my house, because it's even though it's my house,
Yeah, no, it's funny you mentioned.
Yeah, exactly. I mean, and this is what we've been talking about. Of course, it's expected that you search your house, which is why also this has to be stressed during the closing arguments. Why wasn't that house searched? The house wasn't searched because he's a Boston cop. That's why it wasn't searched. That was their whole approach to this investigation. They're going to protect their own. That's it. You don't have to go into the whole conspiracy, and therefore they framed her. Stop before that. You can stop before that and say, look, one thing is clear about this case. There's preferential treatment. They were protecting their own. That's clear. Every other person's house in the world would have been searched. That alone shows how this investigation was done, and it continues. And that's why they're kind of trying to, keep a blind eye and not investigating the case more thoroughly. Maybe if they would have investigated the case more thoroughly, maybe we'd have other options here. But because they decided to put on the blinders and not investigate their own, that's why we are here today. So forget, whether she's framed, you don't have to go to the next step. That is clear. It's common sense. This is an EMT. He doesn't have any, experience in the law. And he's just saying to himself, yeah, of course my house would be searched. So yeah, that's something that has to be stressed again in the next trial if you're the Karen Reed side. Okay. Now he talks about the inverted video. And just listen to the common sense, because a lot of this is just common sense talking.
Court.
Yeah, and what did you guys think of the inverted video that was shown in court? Did you think that was on purpose? Did anybody think that was an accident?
It was definitely confusing because we all kind of thought it was on one side of the vehicle versus the other side. They were all on the right side versus the left side. And ultimately, when we realized it was inverted, it could be a honest mistake, but it's kind of hard to make an honest mistake when you have to work hard to invert a video, right? I think it's not common to create a copy and then invert it.
So he's not an expert in computers. This is just common sense. So he's saying, yeah, I mean, for a video to get inverted, usually you have to do something to invert it. That takes action. So yeah, I guess you can mistakenly do that, hit something on your computer, but this is a criminal case. You're trying to throw someone away for life. Be more careful. But this is common sense. And this is why I told you, like, the common sense jury instruction is so important, which is why I really stress that in my closing arguments. Use your common sense. Common sense will set you free. And we're seeing exactly how it plays out here. Now, he also said another thing about that they did have a medical group who was part of this jury. Like, there was a few people. He's an EMT. There's a nurse, I think, there. There's some other medical professional there. And all the people in the medical group agreed that these injuries that John O'Keefe sustained were not consistent with being hit by a car. And what he said was that the medical group, this is the jurors talking, the medical group was trying to explain to the other jurors who wanted to convict Karen Reed, at least at count 2, that it's not consistent. How can you convict her when we know that these injuries were not from the car? And they just kept coming back to, well, I mean, what other explanation is there? These are the two people that were there. I mean, how else did this happen? And that's the danger. I keep telling you, that's the danger. You got to tell the jury, you're not here to solve this crime. You're not here to solve the mystery. You're not here to solve the puzzle. Their case doesn't fit within the evidence and the science. Period. That's the end of our job. But since they kept saying, well, then who else did it? Doesn't matter. That's what you have to explain to the jury. Okay? Now I'm going to show you one more clip, which I think also just drives home one of the parts that I kept talking about while I was covering this case. And that simply is that there's just too much focus on the conspiracy. You may believe the conspiracy. When you're talking to jurors who have no idea about this case, it's always hard to convince people of conspiracies. And in this case, you don't need it. You absolutely don't need it because there's so much reasonable doubt. You can win your case on reasonable doubt. And listen to what he says right here.
That will go along with this is like that. Do you think that they focus too much on the conspiracy aspect of what happened and not enough just on, look at, dude, there's no way this guy was hit by a car because that's what the science says?
I think that would have been helpful because really creating the distractors, whatever distractors that may be, like he went inside the house, he got injured inside the house. There was the dog that bit him. There was, injury in the weight room downstairs. All of these became kind of like theories and confusing or distractors to the jury. So ultimately, they just looked at the facts, and the facts were there's damage to the vehicle, right? So a simple look at it is two individuals were there. Somebody was operating the vehicle under the influence. There's damage to the vehicle. It's a broken tail light. There's injuries to John O'Keefe, and now he is dead. Then who's ultimately at fault? the operator of the vehicle.
You keep saying distractors, and that's what they were arguing. But their entire defense is third-party culprit. So are you saying that not the most effective defense for if you were coaching their lawyers for the second trial, like would you say that isn't that as effective as you guys think it is?
I don't think it's as effective. I think it would have been better to focus on the evidence that the state is trying to promote, and focus on those and show the holes on those, or create the reasonable doubt based on those pieces of information. So, for example,
So that's exactly what I've been saying this entire time. We don't tear examples, and we already know this case. I've been telling you from the beginning, don't take on this burden. Don't present two options to the jury and say, pick one. That's not what you want to do. You can say that there's maybe some other ideas here. There's a lot of information we don't know. All of these things that we keep finding, these anomalies, they point to something that we don't know, but that's not our job. Our job is not to present you with theories as a defense. Your job is just to show that the Commonwealth didn't prove their case. That's what the focus should be. Not did he get beat up and was he pushed down the stairs, or was he beat up in the weight room? When did the dog attack him? Did it talk to him now? Did it talk to him right before his death? All those questions are really irrelevant. The point is that the Commonwealth just simply can't prove their case. Again, this is all going in the first case. We haven't seen the second case yet, but he's talking about the first case. So that's what we're talking about. And definitely, like I've been saying from this whole time, the first case should have been focused much more on just the reasonable doubt. Forget about the third-party culprit. Forget about trying to prove a conspiracy theory. Yes, still point out all these anomalies, point out the butt dial, point out the fact that nobody saw the body, point out all these things, but don't say, and therefore there's a conspiracy. Don't do that. Point it all out and say, there obviously is not a full investigation here. We don't know too many things. If you don't know too many things, don't just throw her in prison for life because you're not sure. If you're not sure, then your verdict has to be not guilty. So again, it was a very interesting interview, fascinating. I think it's worthwhile to look at it. This is a real juror who actually sat through the deliberations, giving us his thoughts about what happened. And again, his issues with the jury instructions and the verdict form and the slips, and there's 2 slips that came in, this is a very thoughtful, very educated, very smart person. So you see that even very intelligent people can get confused by this whole process, which is why it just makes our jurors much more important, to make everything much more simple, to make everything explain. You explain everything. And that's the way to win your case. So that's going to be it for now. If you haven't yet, please subscribe, like. And there's been a lot of motions before we go. There's been a lot of responses by the Commonwealth, and then some other motions that were filed, the motions for sanctions, and some responses by the Commonwealth. We got a lot to do this week. So we're going to be breaking it all down for you, just like we usually do. And just keep it here. We'll be breaking everything down, doing some research, and hopefully doing some recapping. There's going to be some hearings, I think, this week. Maybe something got changed from 9 a.m. to 11 a.m. We're going to keep track of all that. So just keep it here, and we will make sure to keep you updated and informed on the Karen Read case. All right, so that's going to be it for now. If you haven't yet, now you can subscribe, like, and we will see you next time.